Lady.
Yes, Mr.
A few words by way of introduction. Mr. Barton is not an inexperienced litigant. I adopt Lord Wilson's point this morning. He's been engaged in litigation with these respondents for over 10 years, having engaged them to act on his behalf in respect of a claim against an earlier firm of solicitors. A breakdown in the relationship caused Wright Hassall to apply to come off the record over 10 years ago. He contested that application unsuccessfully. He was ordered to pay the costs. He appealed that decision unsuccessfully. He was ordered to pay the costs. He resisted payment of his outstanding fees. There was a summary judgment. He was ordered to pay the costs. He has subsequently contested costs hearings. The claim which he now seeks to bring in these proceedings seeks to recover in its largest part the costs which have been awarded against him in earlier proceedings. You'll not be surprised to learn that should this action ever proceed, there is an interesting point of collateral attack down the road. The damages are set out in the claim is set out page 280 of the core bundle. The claim amounts to a total of just under £30,000. £8,000 is said to be the loss of a chance of getting the full value of his underlying claim. He formulates that as having been worth £60,000, and he recovered £52,000 at his mediation. The next entry is the loss arising from litigation by the defendant that shouldn't have been incurred. That's the accumulated costs. He then inserts his own costs, which obviously he did not recover on application. He then deducts the defendant's costs because these can be voided and the charge on his property removed. And that leads to the sum claimed. In the past, Mr. Barton has fallen out with other practitioners representing him because they would not run a claim in the way he wished, regardless of their professional obligations. Can I take you back to the core bundle at page 257? These are Mr. Barton's particulars of claim. Material also to the question of whether or not he was aware that solicitors would need instructions. At paragraphs 293, Nelson's, subsequent firm of solicitors, failed to follow instructions to challenge the defendant's conduct. On the 28th of February 2010, the court issued an order listing the permission to appeal hearing for 22nd March 2010, but making an observation on the face of the order as a result of Mr. Oliver, that's a representative of Wright Hassall's, uncorrected intervention that the claimant may find it difficult to sustain his arguments. 294, the claimant's relationship with Nelson's broke down because they were unwilling to draw Mr. Oliver's conduct to the court at the forthcoming hearing. And finally, in the background, by way of introduction, in the context of service, if again in the particulars of claim you turn to page 230, well, perhaps I should start on page 229 at paragraph 125, final sentence. the claimant is unhappy that the defendant wrote to Reynolds Porter Chamberlain indicating that he would be in agreement to an extension of time without asking him first.
Sorry, which paragraph?
Sorry, my lord. Paragraph 125, final sentence.
Oh, sorry. Thank you.
And then over the page, on page 230, paragraph 130. On the 18th of January 2007, the claimant's email Mrs. Perry, the claimant emailed, I think it should have read, Mrs. Perry, to ask why the former partners of Bowen Johnson solicitors were not served by post. Mrs. Perry replied on the 19th of January in a letter countersigned by Mr. Oliver stating, quotes, "The reason why Mr. Bowen and Mr. Saunders were not served by post is that upon checking their current position, as I would do in a situation out of an abundance of caution where we're so close to limitation, it was clear both of them had moved from the addresses that I had for them. Having to take the time to find out where they were, there was insufficient time for us to safely effect service by post." Once again, Mr. Barton was also aware of the importance of service of claim forms.
That's the claimant taking the point that
his solicitors had not gone about it by service by post. They had effected personal service. So right at the outset, just in the lead up to the breakdown in the relationship between appellant and respondent, the very issue now before this court was the subject of dispute between them. In the respondent's submission, the decision of the Court of Appeal was in all material respects correct. This court set out the approach to be adopted in the decision in Abella. That decision was fully in the forefront of His Honour Judge Godsmark's mind when he determined the issue. He delivered an extempore judgment, and as we've seen, it is susceptible to analytical criticism. That criticism was engaged by my learned friend before the Court of Appeal in this case. The Court of Appeal analysed the law, analysed the judge's findings, and concluded that there was no good reason to overturn the judge's decision. I'm tolerably confident that if one had asked Lord Justice Floyd or Lady Justice Black, as she then was, to critique the judicial technology of Judge Godsmark's extempore judgment, they would both have said the reasoning could have been expressed better. Lord Justice Floyd, with whom the other judges agreed, rightly concluded that at the end of the day it was clear that the judge in the county court had addressed the crucial issue by reference to the obvious determining authority. And it may be useful at this stage to move swiftly to the judgment in the Court of Appeal that we haven't spent much time on today so far, and to just run it through to make good that approach. Page 145 of the core volume. And perhaps one should start it by saying, although Lord Justice Floyd didn't say it, one is conscious in a case of this type, particularly from an extempore judgment. Extempore judgments, I suspect, relatively rare in this court under consideration, that what is appealed against is a decision, not reasoning. And it's in that context that Lord Justice Floyd's judgment comes to be considered. And it is clear, as my learned friend has said, in the authorities which have followed on, other judges have found assistance in the formulation which he adopted. So he sets out...
When you say what's appealed against is the decision, not the reasoning, I mean, if there was a substantial flaw in the circuit judge's analysis of the rule, then the Court of Appeal would have had to decide what to do about that.
Absolutely right. What they concluded, on the other hand, was that he had in reality, notwithstanding some infelicitous formulations, addressed the core issue.
I follow you say that. It was just when you said it's the decision, not the reasoning,
Yeah,
but I felt that needed some qualification.
My Lord, I understand that entirely. Page 145, Lord Justice Floyd sets out what the claim is about. He identifies the relevant parts of the CPR. And although the authors have, as it were, implicitly received a certain degree of criticism during the course of the morning, and possibly explicitly as well, in our submission, Lord Justice Floyd is correct when he says that these are not technical rules. The central rule at 615, that's to say the permissive provision, where it appears to the court that there is a good reason to authorize service, the court may make an order permitting service by an alternative method. And it's therefore no surprise that this court in Abella determined that the key question to be answered was, what is a good reason? It was not, as somebody might have said elsewhere, rocket science. The question is whether, in all of the circumstances, a court is satisfied that there was a good reason. We'll come back to Abella later, but this court is well aware that Lord Clark was explicitly deprecating the creation of a body of jurisprudence and indicating this was quintessentially a matter for the determining tribunal, taking into account all of the circumstances. He then goes on to set out CPR-PD, the Practice Directions 6A provision, headed service by fax or other electronic means, subject to the provisions of Rule 6.23, Subrule 5 and 6, where a document is to be served by other electronic means, the party who is to be served, or the solicitor acting for that party, must previously have indicated in writing to the party serving that the party to be served or the solicitor is willing to accept service by other electronic means. And then it sets out what are sufficient written indications. A fax number alone is sufficient. An email address, but only where it's stated that the email address may be used for service. (4.2), where a party intends to serve a document by electronic means other than by fax, that party must first ask the party who is to be served whether there are any limitations to the recipient's agreement to accept service by such means. For example, the format, maximum size of attachments. The whole process of electronic communication is one which has transformed during the life of the civil procedure rules. If one were to go back to 1999, I rather doubt whether the bulk of individuals in this room were communicating electronically. The fax was producing fading material for us on an hourly basis. Electronic communication was at its outset. And this court will recall that it was by no means universal and by no means reliable. There were issues as to size of documents, as is clearly identified. And clearly, the authors of the rules and the Rule Committee have had to review and consider over the years how the rules have to be changed and refined to deal with modern forms of communication. And in our submission, that is something they have loyally done. My learned friend objects to the route that they have taken. But at the end of the day, what is an important consideration both for the formulation of rules and for the decision-making process in applying those rules is a significant degree of judicial certainty. And changing the rules on an ongoing and regular basis is one of the many ways in which the process of litigation can be made significantly more difficult rather than easier. My learned friend complains vociferously that the rules treat the service of the claim form, the originating process, in a very different and much more rigorous way than other documents. So they do, so they always have, and I would submit, so it is likely they always will, because it is that process of service which engages the recipient party in the litigation. It's not the issue, it is the service of that document. And therefore it is barely surprising that that is a process which is firstly formal, secondly is constrained by the court as to the nature of the formality. And that's not only because of the importance of initiating party and drawing another party into a litigation process, but it's also because the precise moment at which things start is important to the management of litigation thereafter. In the same way that the precise moment that a claim form is issued is of importance to quintessentially limitation periods. A learned friend could have made in a different case all of the points he makes today as to the draconian consequences of failure to serve a claim form correctly in respect of failure to issue a claim form in time because of limitation consequences. The law does, in a limited number of cases, grant a discretion to extend limitation periods. We know that particularly in respect of personal injury claims. In the great bulk of non-personal injury cases, however, there is no discretion. It is a hard-edged procedure of which a litigant in person may have no knowledge whatsoever. And my learned friend suggests that this rule is difficult to understand. It is, by comparison with the Limitation Act, a primary school provision. There are significant areas of the law which are complex. That is inevitable. It has been recognized in the judgments of Lord Justice Morbick, Lord Briggs in the lower court, in the two cases which we'll come back to later. That is inevitable. But these rules are not difficult to understand. These rules are readily accessible, not only online, but also, I would suggest, by attending a citizens' advice bureau. We would respectfully submit that before this court is persuaded that it is in a position to utter significant comments as to where information is or is not available, it would require far more thorough research than is presently before it. I, for example, Googled the words claim form service yesterday and was the first non-sponsored receipt what took me to CPR Rule 6 on the Gov website. Searching the internet fulfills the first rule of electronic information: garbage in, garbage out, or in other words, the quality of the product reflects the quality of the service. And while I'm on that point, of course, so far as Article 6 and access to justice is concerned, no litigant in Mr. Barton's position had to engage in a personal process of service whatsoever. The default position under Order 6 Rule 4 is that the court will serve unless the claimant opts out of that process. That's at page 465 of Volume 1 Authorities. And we know that Mr. Barton opted out because we have the letter which he received in answer to the letter mentioned this morning, which we have not seen, and that letter appears at, thank you very much, 288, page 208. And while I'm there, perhaps I can take you on to page 284, which is the certificate of service. Which he received back when he issued the claim form. Obviously, he had it for 4 months before he filled it in. But if one needed any further guidance as to how to serve a claim form, if you look at the top of page 285, the second page of the Certificate of Service, you see that rules relating to the service of documents are contained in Part 6 of the Civil Procedure Rules. It gives the gov.uk reference, and you should refer to the rules for information. A claim form served within the UK in accordance with Part 6 CPR rules is deemed to be served on the second business day after the claimant has completed the steps required by CPR 7.5.1. So again, there was another clear and unambiguous steer to the source of the relevant information. Returning, if I may, to the judgment of Lord Justice Floyd then, at page 146 of the core,
Sorry, could I have that number again, please?
146.
Thank you.
Lord Justice Floyd sets out the applicable law. And I do not understand any criticism to be directed to the Court of Appeal in respect of this analysis. It starts, as inevitably it must start, with the Abella decision. And Abella was, of course, a very different and difficult case. Mr. Abella was patently evading service and had, in the terms of the later default judgment, clearly 20 million reasons in dollar terms for doing so. It is in our submission significant that a number of these cases arise in the context of service of proceedings overseas. When you come to look back at the long extracts from the CPR, which my learned friends have placed in the court, if you go through the process of putting a line through each of the pages relating clearly to either foreign or other proceedings irrelevant to Mr. Barton's consideration, you end up with a remarkably succinct structure for the service of materials. Page upon page of what appears rightly in CPR Part 6 is to do with foreign service. Lord Justice Floyd rightly identified in our submission the key passages of Lord Clarke's decision. In paragraph 5 on page 146, he cites paragraph 23, reciting the reminder to himself, possibly, and to others, that an appellate court should only interfere with the decision if it's satisfied that the judge has erred in principle or was wrong in reaching the conclusion which he did. He returns to the question at paragraph 35. In a case of this kind, the court should simply ask itself whether in all the circumstances of the particular case there is good reason to make the order sought. It shouldn't be necessary for the court to spend undue time analysing decisions of judges in previous cases which have depended upon their own facts. That said, one can, I would submit, readily understand the position of the judge at first instance, confronted with the question, is there good reason? Who will, I would submit, almost inevitably say to those appearing in front of him, what have other judges done? It's what informs the judicial process under the regime of precedent within which we operate. So one understands why Lord Clarke was seeking to avoid excessive excrescences upon his judgment. One equally understands why subsequent judges have been assisted by addressing, as Lord Justice Floyd did, and as the following judges have done, where the authorities appear to have led, because those indications inform any judicial process.
I mean, that simple approach that Lord Clarke puts there, which I signed up to, is very simple. It just says what the section says. And at some point you're going to tell me why the district judge, who we don't seem to have spent much time on, didn't do just that at paragraph 31.
Well, he did, but he was, I think it's a she, actually. No,
She.
it is a he, I beg your pardon.
Yeah.
I don't know why I thought that.
It's always best to check.
It's always best to check the lady.
This court.
What it was accepted that the district judge did not have was the citation of Abella.
Yes, but if all that Abella says was asked whether there's a good reason, I'm not clear why he needed it.
Well, I think it would have been said that Lord Clarke identified the critical starting point, the critical question.
But he then, I'm concerned because I signed up to this judgment, and obviously we must take responsibility for what we signed up to. But I think one's got to be clear to what extent he's actually trying to give guidance of general
Yes.
purpose and the extent to which he's simply trying to deal with a rather special set of facts where games were undoubtedly being played with the service out requirements.
And perhaps, speaking for those outside this building, it is inevitably the consequence of one of your judgments that the district judge, the circuit judge, the Court of Appeal will address any of your judgments as being of general operation, because that is effectively
What we're here for.
why we're here. Or rather, we would expect not to be here if there isn't a matter of general interest.
Moving on, taking the next one, paragraph 36, where he says it's obviously very important that critically important, it gets the attention. Well, obviously that's right. But he then goes on to say that's not enough.
Yes.
And by illustration, I think that's what he's doing, he refers to Elmis and Highgrave as an example of what the mystery of the rule was trying to deal with.
Exactly.
And that case was simply a mistake of serving the wrong person.
Yes.
And that seems, at least as I read that was treated as enough to bring the rule into play.
In the particular circumstances of that case, I can't...
It didn't exist at the time of that case.
Quite.
What he seems to be saying
Quite.
The rule was designed to deal with that sort of problem.
Right. But clearly, it had to be a good reason. There must have been a good reason why the wrong person was served. Now, that may have been because of how the person had presented themselves. One could speculate in a number of different ways. And perhaps that is why Lord Clark deprecated too much time being spent on the earlier decisions, because without knowing what all of the evidence is, it is actually quite difficult to rationalize out what is the core lead to the good reason. But we'll come back to, say, Carley later on, where it is very clear, because it's recited expressly, the four matters which led Mr. Butcher, QC, sitting as a deputy, to reach the conclusion that there was a good reason there. So the critical factor, and we would submit that the meaning to be applied to the critical factor is it's a factor without which you are not going to demonstrate a good reason at all, is that the information, the fact of the claim, the nature of the claim has come to the attention of the party, the proper party. But as Lord Clark says, that is not enough alone. Because, of course, if that was enough alone, there is no requirement for service restrictions at all, because anything does. And that is not consistent, we would submit, with certainty in determining the starting point of litigation. Moving on, in the judgment of Lord Justice Floyd, we get to paragraph 9. Lord Clark expressly approved a passage from the judgment of Mr. Justice Lewison, as he then was. The purpose of service of proceedings, quite obviously, is to bring proceedings to the notice of a defendant. It's not about playing technical games. There's no doubt on the evidence that the defendant was fully aware of the proceedings which are sought to be brought against him, of the nature of the claims made against him, and the seriousness of the allegations.
And why is that picked out? I mean, that's clearly addressed the particular case of both Lord Clark and Mr. Justice.
But one goes on from there in the Abella case to see that, notwithstanding that, Mr. Badrani is disporting himself in such a way as to preclude the formal steps being completed.
He's playing games.
He is playing games.
But I mean, that's not this case.
That's exactly so.
What's the point of picking out a paragraph which is clearly dealing with a different case?
Because I think Lord Justice Floyd is seeking to set out the structure in which the courts are operating.
Well, I think your point is you're adopting paragraph 11 of Lord Justice Floyd, aren't you?
Yes.
Saying that the good reason in Abella was very heavily concerned with the obstructive behaviour
Quite so.
Of the defendant.
Quite so. And so, before we get there, perhaps paragraph 10 is also important, because it recites paragraph 48, and in the passage Lord Carnwath commented on this morning, the relevant focus is on the reason why the claim form cannot or could not be served within the period of its validity.
I mean, that's a perfect example of something being taken right out of context. What Lord Clark, I understood he was saying, was we're not looking at what happened before, but what happens at this particular moment. He's not laying down some sort of rule as to what, that you're simply looking at what could or could not have been done.
No.
It's about the timing.
It is a material consideration. It's one of those issues which arises after the issue of the claim form. And so the question is, why hasn't the claim form been served properly? Is there a good reason to allow it to be served in the way that it has?
He's clearly not ruling out a mistake, because otherwise he wouldn't have
No,
cited
absolutely
elements
right.
of high grade.
But he is clearly identifying it as part of the inquiry which a tribunal may well undertake in answering the key question. Now, it is unfortunate that in his extempore judgment, Judge Godsmark starts, as it were, with that. But for the reasons identified by the Court of Appeal, he then, Judge Godsmark, identifies all of the considerations which have been placed before him and decides that there is not a good reason to allow the service to be deemed effective. So we come on to paragraph 11, as has been identified already, and the key issue in Abella, which shows the good reason. Power and Malloy was a domestic service case, but the reason why that had clearly gone awry was fundamentally started by an error by the court service.
I mean, Lord Justice Floyd appears to have approached the matter on the basis that clearly the court's power of waiver would not be exercised in a case where the result of the mishap was that the defendant didn't have notice of the contents of the document, but the good reason involved was, in Lord Justice Floyd's view, the obstructive conduct of the defendant, and not in itself the fact of notice.
Right. But if there wasn't notice, a critical feature was missing. So if you haven't got notice, effectively you're not going to get to first base. If you have got notice, is there a good reason to go down the alternative route? Is, in our submission, what it boils down to. And he then addresses that by reference to the submissions made, having looked at power and having that in mind. Mr. Elgott submitted that the case showed that claimants who had failed to take all reasonable steps could nevertheless obtain an order. That submission is correct. It's not in issue. Nobody has suggested the contrary. All the circumstances of the case must nevertheless be considered, not just the conduct of the claimant. He then cites the passage from Karki and Lord Justice Akins. And again, addresses both the conduct of the claimant and the conduct of the defendant. Lord Justice Floyd then addresses the Hassall and Nathalie decisions. In the context where my learned friend had clearly submitted that the fact of Mr. Barton being a litigant in person was a material consideration important in determining whether there was a good reason. And that's clear from the scales. These passages in Hassall and Nathalie arise in the context of relief from sanctions, but so does the present application. It's a relief, what is sought is relief from the consequence of a breach of the rules. The route to relief is identified in a different rule of the CPR, but it is nevertheless an application a claimant has to make if the claimant has not complied with the provisions for service. And in our submission, the words both of Lord Justice Moore-Bick and Lord Briggs are both of general import, and in our submission are inevitable. Lord Briggs, perhaps first at paragraph 18 of Lord Justice Floyd's judgment on page 151. I make it clear at the outset that in my view, the fact that a party, whether an individual or a corporate body, is not professionally represented is not of itself a reason for the disapplication of rules, orders, and directions, or for the disapplication of that part of the overriding objective which now places great value on the requirement that they be obeyed by litigants. In short, the CPR do not, at least at present, make specific or separate provision for litigants in person. There may be cases in which the fact that a party is a litigant in person has some consequence in the determination of applications for relief from sanctions, but this is likely to operate at the margins. As a process of self-testing, I attempted to ask myself, what sort of case might one see impact in the context of the operation of the rules because the person whose conduct is being considered is a litigant in person? You may feel it's an unnecessary and unwarranted exercise, but the thing that immediately struck me would be if one was looking at, for example, a committal case of some description, where the consequences for the litigant in person were committal. I could well imagine that in those circumstances, the litigant's failure to comply with, for example, a search order, the strict requirements of a freezing order, the court might well be influenced to some extent by the fact that it was a litigant in person, depending possibly upon how that litigant presented by way of education, experience, resources. I may be wrong about that, but it just struck me that might be an example of a case where it would be inevitable that the court would factor in the absence of legal representation. It's probably unhelpful otherwise to speculate, but what is clear, both from the judgment of Lord Briggs in our submission and from the judgment of Lord Justice Moore-Bick, that the court is not saying there are no circumstances where we would ever take this into account, but it is saying that litigants in person must comply with the rules, as must everybody else, save in unusual, I wouldn't say exceptional, I will say unusual circumstances. And in our submission, that is an inevitable conclusion, because otherwise, a court confronted with a litigant in person who is seeking some form of relief from the court, whether it's relief as to service, relief from sanctions, is going to be constrained to conduct some form of inquiry into the litigant's education, understanding, researches, experience, all of which is, with the greatest respect, I would submit, an impossible burden to place upon a court managing the process of litigation. And the district judges who now see prodigious numbers of cases involving litigants in person would I think, appreciate readily just how impossible that sort of consideration would be, where you had to create effectively a bespoke system for individual litigants across the board. It's barely surprising, I should add perhaps in parenthesis at this stage, that the report of Lee from Birmingham that my learned friend places weight upon sheds no helpful light for the purposes of your considerations in this matter. Because when you look at that report, you will see that 50% of those who were spoken to were present at court on family law matters, and another 25% were present on housing matters. Other subgroups are then identified by way of insolvency. The likelihood that there were, as it were, this sort of inter-party litigation numbers on that particular day or on the days they attended seemed to be remarkably remote. And in those circumstances, it's barely surprising that CPR didn't feature prominently. Coming back then to Lord Justice Floyd, he summarizes the effect of the authorities at paragraph 19. And without, as it were, trespassing into this morning's debate unnecessarily, he is not setting out a set of principles. He is not setting out a set of rules. He is summarizing what the courts have done up to the moment where he is deciding. The effect of the authorities. In deciding whether steps should be validated, the courts should simply ask itself whether there is a good reason to do so. That is unchallenged, as I understand it, in this appeal. A critical factor in deciding whether to validate service under the rule is that the document has come to the attention of the party. That's the whole purpose of service. Again, uncontested. However, it's not by itself sufficient that the document was brought to the attention of the opposite party. Again, that flows from what Lord Clark said. And again, it's barely surprising, because if all that was required was that the document had come to the attention of the opposite party, there would be no need for a deeming provision whatsoever. You'd just say, it's come to their attention. 4, in deciding whether there is a good reason, there will inevitably be a focus on the reason why the claim form cannot or could not be served within the period of its validity, although this is by no means the only area of inquiry. In our submission, that is inevitably correct. And indeed, in my learned friend's written case, he doesn't take issue with it. You'll note that the only issue he takes in his written case is with subparagraph 6. 5, the conduct of the claimant and of the defendant is relevant. It's not necessary, however, for the claimant to show that he has taken all the steps he could possibly have taken. Again, that is what the authorities have indicated correctly. 6, the mere fact that one party is a litigant person cannot on its own amount to a good reason, although it may have some relevance at the margins. Again, clearly established, and in our submission, an inevitable consequence of the court applying its own rules. If one or the other is playing technical games, this will count against him. And the example of technical games is Abella, that is to say, evading service deliberately. An appellate court will only interfere if the judge has erred in principle. So there is nothing in our submission in the formulation of where the authorities take the Court of Appeal in this case, which in our submission can properly be criticised. It's consistent with Abella, it's consistent with the earlier Court of Appeal authorities. It is, in our submission, consistent with common sense and, happily, consistent with the CPR. He then goes on to consider the facts, and he sets out the facts very clearly. It starts off with the delivery of the claim form. What he doesn't recite, but which I do place before your Lord, before the court, is the clear fact that at the very outset, it is Mr. Barton's decision to take himself into the field of personal service. And in our submission, once that happens, Article 6 effectively falls away. Because if there are any difficulties with personal service, the litigant doesn't have to pursue them. The litigant
forgive my relative ignorance on these matters. Why might a litigant ask to do service personally rather than to leave it to the court?
Because the litigant may not yet be fully persuaded that he wants to engage in the litigation.
Ah.
So you're at the end of the limitation period. If you don't issue, you'll lose your claim. But you still have not applied your courage to the sticking post and decided, yes, this is a claim I want to pursue, for example.
Precautionary claim forms.
Exactly so. Of course, in those circumstances, you don't simply have to sit on the claim form. You can serve the claim form and seek an extension of time for particulars of claim. You can serve the claim form and seek a stay pending mediation or some other form of alternative resolution. But that, I think, is the answer to your question, my lord.
I suppose in the context of someone who's got a lengthy particulars of claim to do, choosing to serve himself and therefore choosing the time of service, rather than leaving it to the court,
yes,
more or less subject to counter-court piles in the offices straight after issue, would enable him to get the time he needed for his particulars of claim without having to make an application for an extension of time.
That is a possibility if he has, as it were, left it to the end of the limitation period to contemplate what he wants to put in his particulars of claim.
I'm not sure the limitation, yes, all right, but it would give him, if you like, a bit of procedural wriggle room.
Absolutely.
Without having to make an application for an extension.
That is certainly true, my lord.
Well, these are very lengthy particulars of claim.
They are. Whether Mr. Barton knew they were going to be when he sat down to write them is speculation on the part of all of us.
Well, the first paragraph says that it's necessary to set the history out at some length.
It does that.
Perhaps he wrote that one for last.
But for whatever reason, there are reasons good and bad,
Thank
but
you. Yes.
It isn't inevitable. He engages with Miss Bebbington of the defendant's solicitors, who says right at the outset she'll await service and of the claim form and particulars of claim. There is, incidentally, a complaint in the written case that the defendants did not engage in negotiation or mediation at the outset. I would submit that if you take into account the contents of the nature of the claim in the way that I've set it out to you already, you'll understand why there was no desire or point, frankly, in engaging in mediation in this case. Lord Justice Floyd then deals with the service process, and in particular the delivery of the claim form on the Monday. Mr. Barton, as you know, gets back an automatic reply from the partner, Mr. Nash, and he sets out that evening a document which is missing and hears back from the respondents on the 4th of July. And we then get the history of the matter. At paragraph 27, Lord Justice Floyd identifies the key elements of the witness statement submitted by Mr. Barton. That is to say that he had concluded that they did accept service of documents by email, although he was aware that some solicitors didn't. The district judge's decision is then recited. And the district judge concludes that there was no good reason for disapplying the service provisions. As you know, when the matter came before Judge Godsmark initially for the purposes of granting permission to appeal, he gave limited permission and directed that the skeleton argument should be limited. However, by the time the appeal took place, he was obviously aware of the decision of this court in Abella, made it known to both parties, allowed Mr. Barton as much time as he needed to consider it, and satisfied himself that Mr. Barton was ready to proceed before the matter proceeded. And the matter then proceeded before Judge Godsmark on the basis of the relief in the context of the Abella decision. At paragraphs 34 onwards, as my learned friend has taken you to briefly, the decision of Judge Godsmark is reviewed. He sets out the question, and as I think I've already accepted, the formulation is unfortunate because he appears to put the second consideration as a first consideration, or rather, the consideration which is part of the overall questions posed in the context of Abella by Lord Clark. And at paragraph 37, he says, as was the case, it's common ground on this appeal that the decision of the district judge proceeded on the erroneous footing. There was a two-stage test. I need say no more about the decision, save to admire its clarity.
The paradox is that there was a far more potentially controversial two-stage test in the circuit judge's analysis than there had been in the district judge's analysis.
Right. My Lord, yes. And Mr. Elgott submitted that the judge directed himself by reference to the relevant, despite directing himself by reference to the relevant authorities, fell into error in focusing too closely on the reasons why the claim form was not served in time. He submitted that the judge should have started by asking himself whether there was good reason to validate service. He didn't dispute that it was relevant to consider the reasons why the claim form was not served in time. However, there were other factors which the judge had failed to take into account. And Lord Justice Floyd then sets out the matters which are relied upon by my learned friend in front of the Court of Appeal as being the matters which were not adequately taken into account. One such factor was that the defendant's solicitor had not responded promptly to the email of the 24th of June. He submitted it could be inferred that BLM had deliberately waited until the expiry of the limitation period before alerting the claimant to the defect in service. In our submission, there was no foundation for that inference to be drawn. In fact, the requirement would have been to have responded pointing out the inadequacy of service effectively within 24 hours. He submitted that particularly given that the fact that the claimant was a litigant in person, BLM should have responded to the email in time for him to effect personal service before the deadline on the 25th of June. Their failure to do so was the sort of technical game playing which the courts had deprecated in Abella and Power. So the submission was that the good reason was the failure to bring to the attention of the opposite party the deficiency in service within a 24-hour period so as to permit him to correct it. It requires, as it were, to be held against the solicitor, or rather, it demands, if that's right, that any solicitor confronted with an application of this type must account for the failure to respond instantly as to the deficiency. In our submission, the Court of Appeal rightly dismissed that approach. As to the conduct of the claimant in failing to serve the claim form within the period of its validity, Mr. Elgott submitted the claimant had engaged with the defendant in accordance with the relevant protocol and was not to be compared with the claimant who had served a claim form out of the blue without doing so. He submitted that the defendant and its solicitors couldn't have been in any doubt about the claimant's intention to pursue the proceedings. Well, with respect, there is nothing in that paragraph which could conceivably amount to a good reason for extending the parameters of service. Mr. Elgott maintained the judge had been wrong to characterize the case as one in which the claimant relied solely on the fact that he was a litigant in person. On the contrary, he'd be making substantially the same submission if Mr. Barton had been represented by a solicitor. What then was the good reason? I can't provide an answer to that question. A solicitor in representing Mr. Barton failed to serve in compliance with the rules. There is nevertheless a good reason why service should be permitted to stand. There is nothing in the evidence that was before the judge which would have led to such a conclusion. It was inevitable that any judge hearing this application would ask himself, why wasn't service properly effected? And that was the question which His Honour Judge Godsmark asked himself. What other consideration was there to bring into account to sanction the departure from the requirements of the rules? None is identified.
Well, the one that is identified, whether it works or not, is no doubt a matter on which you will have submissions to make, but the one reason given in the claimant's application is he didn't know about the relevant rules.
Right. That wouldn't be a submission that you could make on behalf of a represented claimant with any expectation that it could succeed.
No, but his case is that a litigant is entitled to a measure of indulgence, bearing in mind that he shouldn't be expected to know all the rules.
But, my Lord, I entirely understand that, and that's why my learned friend's submission as recited by Lord Justice Floyd at paragraph 41 is palpably unsustainable. Because what it boils down to is, with respect, what your Lordship has just said, that is to say, the good reason which is relied upon effectively for the purposes of this appeal is that a litigant in person should be treated differently. And what we don't know, even now, is what consideration Mr. Barton had given to the rules. We know from his particulars of claim that he had engaged with the respondents on the rules for service in the context of the previous litigation.
Well, he says he gave no consideration to the relevant rules because he didn't know about them.
Right. That's difficult to reconcile with his own particulars of claim, my lord. He had specifically engaged with Wright Hassall on whether or not personal service of the partners ought to have been preferred over postal service.
But the relevant rule is Part 6 PD, which deals with electronic service.
Right.
And that acknowledgement, as one, or what you pick up out of the particulars of claim, is something you don't find in the PD, you find that in the main part of Part 6.
You do. That is certainly true. I accept that. But of course, Part 6 does refer you expressly to PD 6A.
Yes.
So, yes, I accept, my lord, you have to go to PD 6A, but Part 6 takes you straight there. And that's clear from page 464. So coming back to Lord Justice Floyd, we then have Maloney Jr.'s submissions, which I will pass over because you're aware of them. Discussion first, and perhaps the only question is whether the claimant is right to suggest that the judge fell into any error of the kind which this court could correct. It is fair to say that in paragraph 10 of his judgment, the judge appears to pose the question, why was it that the claim form could not have been served, as a threshold question, before asking himself whether there was a good reason to make the order sought. Had he left the matter there would, in my judgment, have been much force in Mr. Elgott's submission that the judge had failed to have regard to all the various factors which were relevant and had focused too much attention on the paucity of reasons for non-service. But the judge didn't leave it there. He pointed out next correctly that the critical consideration in deciding whether there was a good reason to validate service was whether or not the claim form and its contents had come to the attention. He went on to refer to paragraphs 33 to 38 of Abella, pointing out again correctly that the critical consideration was not itself enough. He reminded himself in particular of the fact that the purpose of service of proceedings was to bring it to the attention of the defendant, and that in considering the conduct of the claimant, the relevant focus was on why the claim form could or could not be served within the period of its validity. Thus, when the judge said that the whole focus of the appeal boiled down to whether or not there was any reason why Mr. Barton wasn't able to serve the claim form, he already had in mind the critical question of whether the claim form had come to the attention of the defendant was to be decided in the claimant's favour. What he was looking for was whether there was anything in the other circumstances which could be advanced on the claimant's behalf to allow the conclusion that there was good service, there was good reason to validate service. And he concluded there was nothing. In our submission, that was a perfectly proper way for the Court of Appeal to review the judge's extempore judgment, identifying the appropriate test, reciting the appropriate authority, and reaching in our submission the inevitable conclusion. Lord Justice Floyd goes on. It follows that Mr. Elgott's reliance on the proposition from Power that the court may in principle grant relief under 6.15, notwithstanding the fact that all reasonable steps have not been taken to effect service, in this case gets him nowhere. It's right, the court can give relief if there is a good reason. There wasn't a good reason here. The judge also considered whether the claimant should be excused from complying with the rules because of his status as a litigant in person, and concluded that he shouldn't be. There was ample material on which he could so conclude in this case. The very clear terms of the rules about electronic service, the fact the claimant was aware that some solicitors did not accept service by email, the fact that the claimant did nothing to check directly with BLM about whether he could serve by email. There was no evidence that Mr. Barton had even looked at the rules. The judge was entitled to take the view that this wasn't a case where any special indulgence needed to be afforded to a litigant in person, as might, for example, be appropriate where the rule in question was difficult to find or ambiguous to a non-lawyer. In our submission, again, Lord Justice Floyd was entitled to reach that conclusion. Then went on to consider the defendant's conduct, technical game playing. Now, as I understand it, technical game playing has been presented by my learned friend in a number of different ways. Firstly, he says, failing to respond instantly to put Mr. Barton on notice of the deficiencies in service is technical game playing. And as I understand his submissions to your lordships, probably follows a deliberate decision to do so. In our submission, there's no foundation for that. Or secondly, taking the point at all is also identified in his written case as being a form of technical game playing. In our submission, Court of Appeal rightly factored in to the first form of criticism the fact that solicitors in circumstances such as the present have to take instructions. And in a case such as this, it wouldn't be surprising to any court to appreciate that they would have had to have taken instructions from the lay client and from the insurer. So it's not just simply picking up the phone once.
Well, they would have had to advise the lay client that the consequence of waiving this particular irregularity was that an unbreakable statute bar would be lost.
Quite so.
Difficult to conceive that any reasonable client, having been given that advice, would say, well, then go ahead.
Right. And that's before you get to the insurers. But be that as it may, the secondary formulation of technical game playing is taking the point at all. And in our submission, there is no authority which would lead a court to conclude that confronted with the consequences of waiving this point, anybody would conceive that requiring the claimant to demonstrate his entitlement to the relief, which is what the defendant is doing, it is a form of technical game playing. The learned friend sought to draw parallels with minor procedural hiccups during the course of the management of litigation. In our submission, for all of the reasons I've already set out, it has always been and remains the case that the process of initiation of proceedings by service is fundamentally different to steps taken during the course of the litigation. Although that said, there are plenty of examples in modern managed litigation where the consequences of failure to comply with a rule or a court order can be equally catastrophic. Lord Justice Floyd therefore concludes that the judge was not wrong in failing to place weight upon the conduct of the defendant and their solicitors, and concludes that he is unable to identify in any respect in which the judge erred in principle or was wrong in reaching the conclusion that there was no good reason to validate service. And in our submission, that was the correct, indeed inevitable conclusion. Because at the end of the day, the only reason tendered is the fact of Mr. Barton's status as a litigant in person.
Before you leave the judgment, can you come back to the point I put to you before on paragraph 37 as to why it seems to be common ground the district judge had gone wrong in setting up his own two-stage test, because his two-stage test was simply, is there a good reason? If not, I throw it out. If there is, I have to exercise a discretion, which I, in fact, would exercise against him. But on the question of whether there's a good reason, the judge's district judge's reasoning is set out at paragraph 31 of Lord Justice Floyd's judgment. And why is it said that that was erroneous?
But, my Lord, I have to say I haven't spent much time on the district judge's judgment because it was common ground below and I didn't appear below. As I understood the position,
I mean, he didn't have the advantage or possibly disadvantage of the bailiff, but he simply approached the question, was there a good reason?
but my Lord, will you give me 2 seconds just to see if Mr. Banks-Jones can help me on this?
Well, I think I've got the answer, if it helps. The answer is that the district judge decided the case not only by not knowing about a bailiff, if that makes sense, but also it was before the Court of Appeal had given its decision in Denton. So the two-stage test that the district judge employed in this case was wrong because it didn't take into consideration a bailiff, but also it was wrong because what was perceived to be the harshest test in Mitchell, which to some extent was tempered by Denton, wasn't before the court at all. And that's why Judge Godsmark gave permission to appeal, not because the district judge didn't have the benefit of a bailiff, but because the district judge didn't have the benefit of Denton.
Well, I think Lord Conworth's got a jolly good point, but it's all water under the bridge, isn't it?
It is.
Yes.
All right. Is it water under the bridge? I'm not sure it is.
My Lord, unless there are any other questions arising out of the judgment of Lord Justice Floyd, I will move on, if I may. I've already made clear that we do not accept the extensive evidence submitted by my learned friend as to what he says a litigant in person's route to the rules is to be said to be. I'm afraid it's a route to madness because realistically, what both of us are at risk of inviting you to do, which I certainly don't, is to embark upon your own searches to see how you would find and what you would find, or to ask your milkman to do it in your place. Realistically, there is no way in which the courts can seek to do better than the Rule Committee in enunciating the rules as clearly as possible. And my learned friend says, well, these are enormously complex. We reject that. We invite you to reject it. And the comparison of the amalgamated Foreign Service rules and comparing it with the old rules of the Supreme Court is, in our submission, an equally sterile process. The reference to the nature of the court attendees in the Lee report, the reference is page 1081. One sees that after the first quotation, almost halfway down the page, in answering the questionnaires, 49% of respondents stated they came to court as defendants, 37% as claimants. The remainder didn't state their role, with 10% ticking don't know.
No box. That seems a most extraordinary thing not to know.
My Lord, I suspect they are effectively, they're there to support somebody else.
Oh, right. So these are not all actual litigants.
It wasn't identified, it was I think, because they weren't given an introduction to the litigants, and there was clearly difficulties of communication, they were simply allowed to interview people who were present. There may have been some witnesses, for example. About half of the sample disclosed issues relating to family law and a further quarter to housing law. Well, I don't pretend to have any expertise in respect to family law, but the CPR does not trouble. I rather think a book that's red-coloured is rather more prominent in family law matters. And a further quarter...
shorter too.
Yes. And a further quarter to housing law. One can reasonably assume that the great bulk of those will be defendants to rent and possession proceedings, I would have thought.
I suppose some of the 10% ticking don't know might have been family litigants,
They might have been.
where the words defendants and claimants
Quite so.
are used.
Yes. Quite right. These are, in any case, the main issues dealt with by the court, especially if one categorises issues such as domestic violence as a family issue, although the court deals with debt and bankruptcy issues, some social security matters, and some small claims. Those words tell us, I think, quite a lot about the actual business that was being conducted in that court centre. And therefore, the number of cases involving detailed consideration of the CPR is likely to have been very small indeed. Turning to a few points in my learned friend's written case. At paragraph 45, he expresses his suspicion that almost all litigants in person would assume that it wasn't necessary to read the CPR. Well, I'm not in a position to speak to that, save only in this regard. So far as somebody issuing a claim form and taking upon himself the burden of service, he is expressly referred to Part 6, as we have seen in the acknowledgement of service which he receives from the courts. He goes on to say, after all, most car buyers buy cars without reading the small print in their contracts. Most consumers enter into onerous finance contracts similarly. Most footballers play football without ever having read the ever-changing laws of football, even at international level, which is a very curious trio of points to make, because this court will accept, I am sure, that if you buy a car without reading the small print, you are nevertheless bound by the small print in general circumstances, subject to the Consumer Credit Act possibly. Onerous finance contracts entered into by consumers bind the consumers, and footballers playing football are still subject to the rules, even if they don't know them. What that point does make clear is this, that anybody at any place in society engaging in some acknowledged complex process, whether it is football, which is certainly complex to me, purchasing a motor car, or engaging in litigation, knows that there are rules, small print contract terms, and rules of the court, and knows that they impact upon them. Turning briefly to Article 6, our primary point remains the same. There was never any restriction upon Mr. Barton's access to justice. All he had to do was invite the court to effect service. In our submission, the service provisions, the subject of very careful consideration and review and alteration over the years not only under the rules of the Supreme Court, but also under the civil procedure rules, demonstrate a mature and considered consequence of the Rules Committee's conclusion as to the requirements for certainty and efficient management on behalf of all litigants, so that everybody knows where they are. There is no bar to access to the court. A claimant who leaves matters to the 11th hour has the risk of severe consequences. But that is no different from the claimant who leaves the issue of the claim form to the 364th day of the 6th year. There are a number of different areas of the law where there are serious consequences. They are required by the law in the balance of the rights and interests of all parties in order to achieve certainty and efficient management. And this is no different. My learned friend puts his case, I think, in respect of litigants in person, and I think this is also applicable to Article 6. At its highest, I think, at paragraph 87 on page 72. Until October 2015, there was nothing in the CPR to suggest that litigants in person should be treated differently. In particular, there is and was nothing in CPR 3.9 which allowed the court to exclude the fact that the litigant was acting in person from all the circumstances of the case. As a matter of ordinary statutory construction, if this is a relevant circumstance, then it has to be considered. The issue is only as to the weight to be given. It's relevant that even a litigant in person who has read the CPR would not know that the fact that he/she was a litigant in person was only relevant at the margins, unless he/she had studied the case law as well. I understand my learned friend's point there to be that the litigant in person, Mr. Barton, has the further obstruction to their route that they may not know the significance of their status as such. In our submission, that is yet again a demonstration of the impossibility of imposing a distinction on that basis. My Lords, the final matter raised by my learned friend this morning is the appeal in respect of costs. The costs were assessed by way of summary jurisdiction in the courts below. The Court of Appeal had before it all of Mr. Barton's points and reached the figure that it reached. In our submission, unless your lordships would wish me and ladyship would wish me to do so, I don't propose to say anything further about an attack upon the process.
Thank you.
Unless there's any further matters on which I can assist you.
It appears not, Mr. Pools. Thank you very much indeed. Mr. Banks-Jones? Yes, Mr. Elgar.
Milady. Milady, sometimes I wish that I had been arguing this error without the claimant being a litigant in person, because it strikes those of us on this side that, given that our primary submissions are that this is a jurisdiction which will enable the court to correct errors, If this, in my submission, minor error of no consequence to the defendant whatsoever, is not the kind of error that 615.2 was designed to absolve from a striking out, then it's difficult to see why Lord Clarke in a bailer was prepared to refer to the White Book when it itself referred to the case of Elms. Because the case of Elms, which is at, forgive me, it's at 722, behind tab 7. What was a case, paragraph 2 has got the description that at bottom of paragraph 2 on 723, the last day of the 4-month period stipulated for service, the claimant's solicitors faxed the claim form to the defendant's insurers. So that was on the last day. If one turns over 726, line 2, it is submits Mr. Porter sufficient good reason that the defendant's insurers, who had been faxed, were in fact dealing with this claim, and that they would suffer no conceivable prejudice, although the proceedings being served on them rather than upon the insured. So the mistake that was made by a represented claimant in Elms and Highgrade was that faxed service, which was permissible, was sent to the insurers, who were the paymasters, rather than the insured, who had no financial interest in it. And so that was the same type of mistake that my client has made in this case. The difference being that my client wasn't my client was a litigant in person. So if one starts from the premise that 615.2 includes the validation of service where there is a mistake, but no prejudice, no cost, it's electronic form rather than paper, then one would expect under 615.2 the court to say that there is good reason to authorise service. Now, my learned friend fell into the trap at one point of talking about a good reason to fail to serve in accordance with the rules. And that's the same error that has been made historically in this case, because the focus has been on whether there was a good reason not to serve in accordance with the rules. But that's the wrong test. As is then said, well, there's never a good reason not to follow the rules. And it's true. But that's the wrong good reason. The good reason is the good reason to authorise service. So Mr. Barton didn't have a good reason to serve electronically. It was against the rules. But there is a good reason to validate service. It's because his failure to comply with the rules didn't make any difference. Because service means the getting of the claim form to the defendant in time. And the additional factor is that which takes this case really on the claimant side is that he said to the solicitors he was sending it to, please find attached by way of service. So there was no doubt that reading the covering letter, email, and the claim form, and the service pack, and everything was sent by way of service. And that, by itself, in my respectful submission, is a good reason to validate service, just like it would have been in Elms, and just like it would have been here, if Mr. Barton had not been represented. But the fact that he's not represented can, in my respectful submission, be a gloss on this as well. And so this case is emphatically not premised on the fact that he was a litigant in person. Being a litigant in person is just one of the factors that a judge ought to take into consideration when doing the evaluation that's required for 615.2. Now, perhaps it would operate on the margins in some way. We don't know what future cases there might be. In my respectful submission in this case, it wouldn't need to operate much more on the margins if it needed to operate at all. But in all of these cases where there have been mistakes made, the court can say, well, if a solicitor does something in relation to service by mistake, then that's the end of it. Not much point at looking at any of the other factors at all. But if it's a mistake, if it's a mistake made in good faith, I suppose if a solicitor did this for a second time, it would be a mistake or not made in good faith.
I mean, I wonder whether this distinction that you draw between a good reason for not having served in accordance with the rules and a good reason for waiving the rules in a particular case is actually a real distinction. I mean, you yourself say, well, the reason was that this was a mistake. That involves having a look at why he didn't serve in accordance with the rules. I mean, can you really distinguish these two things?
Well, but with respect, the court has a choice. The court has to say, if a mistake has been made in relation to service, then 615.2 prima facie doesn't apply.
I mean, you appear to be submitting, unless I misunderstood you, that the reason for the failure to comply with the rules is irrelevant. All that matters is the consequences or lack of them, one of which, of course, is the loss of a limitation defence. So I'm not sure that your point about lack of prejudice is really valid, but...
Well, there was no prejudice at the point of... There was no prejudice at the point of intended service and of receipt of service. Clearly, there's prejudice in the loss of a limitation defence. But with respect, the court really ought to be focusing on the time of receipt.
In other words, on the reasons why the thing was not sent, the reasons why the thing was sent electronically without prior consent. I mean, you seem to me to be having your cake and eating it, or trying to. If one's focusing at that moment, then what have you got to focus on other than the circumstances in which the claimant has come to this particular pass?
Well, you're focusing on the fact that the defendant's got everything it needs, and that is focused on in a bailer. But
could I just take you back? You were referring to Lord Clarke's reliance on Elmis and high-grade food.
Yeah.
He was in fact referring to the note to the 2013 edition of the White Book. Do we have that, the note to which he is referring?
my lord, no.
No, okay.
I'm not sure it's easy.
Well, obviously it can be found, but we find it within the building.
I mean, there is within the authorities bundle as well an article written at the time that this came out, again in the Law Society's Gazette, by Robert Hill, who was on the Rules Committee, explaining how this might save a case with similar facts to Elms and High. I'm told it's a 1052, where service has been made mistakenly. It's 1052, 1053, and on 1053, an example is given where. It seems to be based loosely on Elms and Highgreave, but the point is, it's where a solicitor makes a mistake. It's the bottom part underneath the pictures of two gentlemen in kilts.
Yes.
Well, that seems to be making the same point as the note was apparently making.
I'm sorry.
No, I'm saying that seems to be making the same point as you
Yes.
say.
Yes.
Okay.
And so, can I also deal quickly with some other points? Again, I think I can deal with this in a couple of sentences. My learned friend started by referring to the particulars of claim. I'm not going to take your lordships through the particulars of claim, but he asked his solicitors, why do you waste money on personal service when you can serve by post? Which is not quite.
When you can serve through the court, I think was his point.
Well, when you can serve by post, I think. But
No, he was picking up a point from the particulars of claim.
I see.
yeah.
Particulars of claim.
But it's slightly different from knowing the rules. Well, knowing that there's a practice direction that deals with electronic service. One point I've probably not noticed before, but when we were going through CPR PD 6A411A and B, which are the it's dealt with at 146 in the judgment, which is probably the easiest way to find it. Page 146. So this is the rule that is apparently easy for litigants in person to follow. Once the litigant person has actually got to CPR PD 6A, service by fax or other electronic means, there's reference to various matters. If you turn over the page, 2, the following are to be taken as sufficient written indications for the purposes of paragraph 4.1.1 in brackets. A fax number set out on the writing paper of the solicitor acting for the party to be served. B, an email address set out on the writing paper of the solicitor acting for the party to be served, but only where it's stated that the email address may be used for service. Now, my Lord Sumption makes the point, well, if the principal hasn't given the agent permission to accept service by email, then the agent can't act in a certain way. On the other hand, the likelihood of the principal giving the agent permission to accept service by fax in reality, is right. Well, it's rather unlikely, and yet a fax number set out on the writing paper is sufficient. The claimant serving doesn't need anybody's permission. It's enough if there's a fax number on the note paper. Now there may be a reason for differentiating these two matters, but it doesn't immediately leap out at one what that reason is.
I mean, these rules are all subject to the solicitor surely having the authority of his client to accept service by some means or other, and they appear simply to indicate what the technical process is to be.
Well, the point I'm making, that if the headed note paper has on it a fax number and an email address, the fax number alone enables the claim form to be served without further ado.
Even if there's no authority on the part of the solicitor.
Yes. I mean, that's what the rule says. But for some reason, which would not be entirely clear either to a claimant's lawyer or to a litigant in person, you can serve via one address, apart from the postal address, but not by the other. And again, it seems harsh that a claimant might lose his or her case because of this.
Well, Mr. Elgort, you have had your allotted time for your reply.
And I'm very.
It's not really up to you to take advantage of the fact that Mr. Poole's is slightly shorter than he had
I was hoping I could, but if I can't, I can't. Just to say that paragraph 111 of my case demonstrates that I do take issue with Principle 6. My learned friend said there's nowhere in the case. But it's paragraph 111 of my.
I think that he said that you didn't take issue in your written case with Principle 4. You did take issue with Principle 6, but not with
no. I'm
4.
sorry. I'm sorry. With Principle 4, it's just that I can't read my own Roman numerals.
No, well, we might have got them the wrong way round.
Anyway.
We won't speculate about
It's
that,
it's all made clear in paragraph 111.
And you will realise that, although I've been a little bit hard on you as far as time is concerned, you did have considerably more time than Mr. Poole's in any event.
I did, and I paid tribute to Mr. Poole for agreeing to that in advance, without the slightest demur.
Well, thank you all very much indeed for your representations, both oral and in writing. And we shall now go away to puzzle out what we think the answer is. Court is now adjourned.